Since times of antiquity, human civilization has in one way or the other depended on agreements. A series of promises and agreements which later evolved into legal code are what was first known as contracts. According to Pollock, a scholar of legal services, India, a contract is a legally binding agreement and promise between two parties and is enforceable by law. An illustration of how people enter into a contract, or rather form a contract, is shown in the first clip of the video. All individuals have the power or right to contract and freely determine the provisions and obligations without any unreasonable legal restrictions, which is known as freedom of contract. But this statement excludes the incapable individuals who fail to meet the criteria of capacity. What is capacity? Capacity to contract means a party has the legal ability to enter into a contract. Capacity also means a person has to be competent as defined by law. Someone's capacity is determined by whether or not they have reached the age of majority and if they are mentally capable of understanding the applicable contract terms. As seen in the illustration of the video, both parties have got the ability or the legal ability to form a contract.
She want the fun, I give her one time, now she come from I think too long, she want to test in my cockara. My dear, make I tell you, I know they want to do like say, me I supposed to go holiday, but I want to stay. She thought I was lazy, she said baby don't blame me.
This video shows an illustration of a capable party who entered into a contract with an intoxicated person, of which, under contract law, the law excludes intoxicated people because they are not in the right state of mind to fulfill the obligations or rather lack capacity to enter into a contract. But the courts of law may decide that if a person is not too drunk to know what they are saying, then that contract may be considered voidable and can be rectified once the intoxicated person gains conscious. Moving on to the next video shows a person in the right state of mind entering into a contract with a mentally ill person. But the status of mentally ill people have some special position. They are natural and have legal identity, but are not capable to enter into a contract. If at the time of entering into a contract, the mentally ill person is incapable of understanding the nature of the contract, then they are considered to be incapable of entering into a contract. If a party falls mentally ill prior to the completion of the contract, it is considered voidable, especially if that contract contains specific clauses which states that if one party or the other becomes mentally ill before the completion of the contract, then with written notice of the same, the contract could be nullified. In accordance to the case of Brennan versus Omiera of 2009.
We're supposed to sign at least to validate this same contract. So I will have you sign. So here is what I'm going to sign, and you scribble. Yeah, that's it. Thank you, ma'am. What's happening? Madam, what's happening? Hey, madam, what's happening? Madam, wait. What's wrong?
Lastly, we'll talk of entering into a contract with a minor. A minor is an individual who has not attained maturity or is under the age of 18. A minor by law is recognized to lack the capacity to contract. The rationale is that minors lack a full understanding of the consequences of their contracts. Most of the times, contracts with a minor is seen as void. This is because the law permits the minors to render the contracts earlier signed void. This implies that in a contract with a minor, the minor is not legally bound to the terms of the agreements unless the contract is within the sentence specified. An example of this can be entering into a credit transaction with a minor, simply because a minor is not capable to pay back or pay half of the money. That example, entering into a credit transaction with a minor as shown in the video.
So despite me giving this girl my laptop, she doesn't want to pay me back my money. I'm gonna sue this girl. Hey, how are you?
I'm okay, how are you?
I'm good. How is everything? How is the laptop?
Fine. The laptop is okay.
Hey, when are you giving me back my money?
I can't give you back the money because I don't work.
Like seriously?
Yes, and the games that are in here are not even benefiting
Hey,
me.
wait. Do you know that I can sue you for what you are doing right now?
You can do whatever you like, but I can't do anything. Like, I can't give you back the money. I can't.
I'm gonna sue you. I'm gonna take you to court.
I can't
You're gonna give me back my money, or you're gonna give me back my laptop in court, because I'm gonna take a legal action against you right now. You can't do this.
You can do whatever you want. I don't have any money to pay you back. I don't work, so I can't give you back any money.
I'm going to take a legal action against you, and you're going to pay me back my money in court or give me back my laptop there. See you in court.
So I don't even have any money to give him. I don't even care. I can do whatever he wants. Don't even care. I don't even have money. I don't work. I can't pay him back. He can do whatever he wants. Instead, okay.
Brain power what is Solomon. Italy say yeah. Italy say yeah. Italy say na pambuza Moses nifuna ngazi pepela koma enemy bamene bamani tenga monga kabeji ni pasembambu.
This does not apply to contracts concerning necessities, penalties, military services, instances of minors' age being misinterpreted, or employment contracts. In such instances, the contracts are valid.
Tetekelo monga David, muni konde monga Abraham, muni tumi monga Noah, and zeluza Solomoni. Amboya mundi sokolere, koma so mundi basempango, de pasenenzelo mamene muna pasi la so.
Protecting yourself when dealing with parties lacking capacity. The first thing you have to do is verify capacity. Before entering into a contract, determine if the other party has the legal capacity to do so. The second thing you have to do is seek professional advice. If you suspect that the other party lacks capacity, or if the contract involves complex legal matters, consult a lawyer or seek professional advice. The third thing you have to do is document everything. Keep a record to all communications, agreements, and any other promises made by the other party. The fourth thing is review and negotiate. Carefully review all terms and conditions of the contract, including warrants, retained police, and any liabilities. The fifth thing you have to do is consider alternative dispute resolution. In a case of dispute, explore alternative dispute resolution methods like mediation or arbitration. These approaches can help resolve conflicts more effectively and cost effectively than going to court. Remember, ensuring contractual capacity and protecting yourself when dealing with parties who may lack capacity is crucial as safeguarding your rights and interests.
Atiba kukwila chigololo kulibe kwe uzayenga ndiwe chabe chizeke osawala mami ati ndiwe chabe